I'm sorry, I hope I didn't miss, but how soon can we apply for the application for the business?
Okay, again, as Mavis said, two separate licenses will have to be purchased or awarded. The state licenses will begin accepting applications for the state licensed facilities on August 3rd. And then, of course, the business licenses would come after that once the state license is issued. So there could be a time frame there of 6 months or so between getting your application in for your state licensed facility and then being awarded, and then you would want to get your business license. However, in part of the application process for the licensed facilities with the state that you would turn in on August 3rd, there is questions in there in your application about making sure that you comply with all the local zoning laws and zoning or local laws or what have you. So you would want to make sure and check with the city in making sure that you would qualify with them even prior to applying with us. So there's no surprises down the road there. Yeah.
And what I'm going to say about that is that all of this, what we talk about, remember now, board bill from the Board of Aldermen has just now been introduced. And so once that is finally passed, it will regulate location, establishment, and operation of a medical marijuana facility. It's not the same as a CBD. And so CBD, you can come in right now and apply for those licenses. All right.
Thank you. Yes, I think it is very important to clarify the distinction in medical marijuana and the CBD hemp industry. And I was a couple of minutes late when I got here, so I didn't hear the very beginning of Paul and John's presentation. But CBD hemp is licensed and oversaw by the Department of Agriculture, and medical marijuana is overseen by the Department of Health. And the medical marijuana program was authorized by the voters on November the 6th of this past year with a ballot initiative that was put on by the people, and it overwhelmingly won with a 65% vote margin over two other proposals. So it was one of three, and the one that we have is the one that was overwhelmingly decided upon by the voters. And this became a constitutional amendment. It was Amendment 2 and is now in our Constitution. So there's some very firm dates, very rigid rules that we have to follow with the Constitution. It's the foundation for what our program is to be. And then we have to take that and work beyond that with all of the other rules and regulations in order to make the program what the Missourians expect it to be. Our mission statement is, as the Department of Health, is to make sure that we bring a program to Missouri that is safe and it is what the patients want and desire for their medical needs. And I think that's something that is a little bit different than maybe even the hemp industry. It's more of an economic thing, maybe, and that type of thing. So we have to keep that in mind as we administer this program. But we are well underway. As you know, we've got the rules out there now, and they have been turned over to the Secretary of State's office. And so we're through with the formal rulemaking process. That's not to say there still couldn't be some changes made. We have certain state statutes to follow on that. And so we have to have them totally finalized, and they'll be published on June the 4th. Which is next week, and we are ahead of schedule with that at this point. Then that's a constitutional date. The next date is July the 4th, which, as John mentions, a holiday, so it would actually be July the 5th that we'll begin accepting the patient cards, the patient applications for cards, medical cards, and that's the next big goal that we are striving to reach, and we plan to do that. And that's when anyone that wants to be able to get a medical marijuana card would have to have their certification from their doctor. And that has to be a medical doctor, MD, or a DO, doctor of osteopathy. And then when we get that application, then we will return that back to them with their card if they comply with all the rules, and that we have to do that within 30 days. Then in addition to the patient cards, we also will begin accepting applications for the home cultivator portion and the patient caregiver portion. And this will allow patients to grow up to 6 plants in their home, and or the caregivers to grow 6 plants for 3 patients. And that'll all be on the July 4th date. Then the next date that we are striving to meet is the August 3rd date that I mentioned a moment ago, when we can begin accepting the applications for all the licensed facilities. And the licensed facilities are cultivation, manufacturing, and dispensary, and then testing facilities. And the minimums that were put into the amendment, which is now our Constitution, are the numbers we're going to award for now on manufacturing, cultivation, and dispensaries. We do intend to award up to 10 testing facility licenses in addition to that. And so we have already received pre-application fees of over 500, around 515 at this point, even though we're only going to award about 348 licenses. So this is why the application process is so important, to be very detailed and make sure everyone does their very best, the very best job of presenting their plan for a licensed facility for Missouri, because it's very limited as to how many are going to be awarded. So that's just a little bit of a nutshell, a little bit of history of the industry, and take any further questions. Over here. No.
Do you still expect the applications to be available on June 4th? And then after the August 3rd date, is there a deadline by which you have to submit an application?
Yes. The first question I couldn't hear real well. What was about?
Will the application still be available on June 4th? Or do you anticipate them being available on June 4th?
Yes, the license applications we plan to have available. And the time frame, the window for receiving those in August is August 3rd to August 17th. That's the window.
Thank you for coming. Will your department be hiring inspectors to go around to inspect these places? And if so, how do you apply for jobs and the criteria for those jobs?
Sure. Good question. We will be applying, or we will be having inspectors. Our department will have somewhere around 50 employees altogether, and about half of those will be what we call inspectors or investigators. The other half will be operations folks that will be in the office dealing with license renewals and patient cards and all of that. Call center, we expect up to 5,000 calls a month based on what other states are doing about our size, so it's a pretty busy time. But yes, those inspectors will be compliance officers, and so I don't have the specific details, but those will be on our state job portal and on our website. By the way, our website is medicalmarijuana.mo.gov, and that's the one that you want to periodically check for updates and all the information that you need for the program, medicalmarijuana.mo.gov. But it'll be a compliance position, so background, some law enforcement background maybe, and maybe some similar to auditors or bank examiners, things like that.
How you doing? So for the pre-application fees, for the people that are not selected, where do those funds go to? Do you get them back, or where do they go?
No, they're non-refundable, and that was all put in the amendment that the voters passed. It wasn't done by us. And those pre-application fees were put in by the drafters in order to get the program up and running and fund the program, so it wouldn't take taxpayer money from other sources to do it. And so anyone that filed a pre-application fee should have understood, or did hopefully understand, that that was non-refundable, and those fees if they're not awarded a license. They become part of getting the program up and running.
So where do the funds go? I missed that part.
It goes to fund the program,
Oh.
to build our department, to build the 50 employee department, to pay for the inspectors and pay for the software and the IT, the technology and everything to get the program up and running.
Okay, and then the last question, do you have to have a location or facility for the license before you approve? So do I have to have a location before I apply, or can I say I'm thinking about having it in this area?
In your application, you will have to specify your location. So you would have to have some kind of contingency contract or something with a facility, depending on whether you get a license or not.
What is the ideal candidate with all of the applications that are going to be submitted? What do you look for in a candidate to get approved?
In a candidate to what? I'm sorry, I didn't hear the very end.
To be approved for a license.
For a license? Well, that criteria is, let me just get my book here. There are 10 categories of criteria that were in the amendment that's now in the Constitution for us to base the application process and scoring process for licenses on. And I'll just mention those 10 criteria. The first one would be the character, veracity, background, qualifications, and the relevant experience of the principal officers or managers. Number 2, the business plan, which would be very important, including all the financials. The business plan proposed by the applicant, which in case of cultivation facilities and dispensaries shall include the ability to maintain an adequate supply of marijuana, plus plans to ensure safety and security of qualifying patients and the community, and procedures to be used to prevent diversion and any plan for making marijuana available to low-income qualifying residents. That's all part of the business plan category. Number 3, site security is one of the criteria. Number 4, the experience in a legal cannabis market. Number 5, in the case of medical marijuana testing facilities, the experience of their personnel with testing marijuana, food or drugs for toxins and or potency and healthcare industry experience. Number 6 is the potential for the positive economic impact in the site community. Number 7, in the case of medical marijuana cultivation facilities, the capacity or experience with agriculture, horticulture, and healthcare. Number 8, in the case of medical marijuana dispensary facilities, the capacity or experience with healthcare, the suitability of the proposed location, and its accessibility for patients. Number 9, in the case of medical marijuana infused products manufacturing facilities, the capacity or experience with food and beverage manufacturing, and Number 10, maintaining competitiveness in the marijuana for medical use marketplace. So those are the 10 categories that make up the criteria for the application. Very involved. There's a lot of information there that they're asking for. So that application is going to be extremely important, that it's very detailed, and that all these categories are, everyone does their very best to do that. So,
is that criteria listed on your website along with the application?
Yes, sir. The amendment itself is on our website, so when you go into that medicalmarijuana.mo.gov, you can click the section that says the actual amendment, and it's 13 pages long, and that was the foundation for our rules. And then all the draft rules that we've done up to date are on there also. The application is not on there yet, but we plan to have it on there by June the 4th, which is next week.
So a couple questions related to delivering cannabis from directly to dispensaries to the patients.
Yes.
It says in the regulations that the payment must be received before it leaves the dispensary. How do you anticipate payment being received when you can't really pay online. A lot of credit card companies will not support that, and you wouldn't be able to. Most delivery orders wouldn't be someone coming in to pay cash and then going home and having it delivered to them. And so the second question is, do you have to have a transportation license as well?
That's a good question. You do have to have a transportation license, and we will issue those. There's very different scenarios. We understand that there is some banking institutions that are looking at getting involved in the industry. I believe Mavis might even have someone's coming today to speak about that. The banking industry in other states, there are some banks that have taken on the industry and are helping various businesses. It seems to be getting a little better all the time, a little more and more coming on board. Another option would be actually someone going down and paying for the product, someone that's not certified, not a patient, just delivering the money for the person, for the patient, and then the product could be delivered. So obviously there's still some questions there and some ways of working all those things out, but that's where we're at right now. So.
So when you're considering licensing, are the principal officers of the business required to be Missouri residents?
Yes.
All of them?
51% of the principal owners have to be Missouri residents.
Thank you.
And they have to be residents for a year. I might also mention something that was kind of touched upon under Mavis's time up here, that we will also license all employees that work in the industry. So we're calling these agents. They'll have to apply and get an agent card. So if you're a transportation person, if you work in a cultivation facility, if you work in a dispensary, manufacturing facility, it'll be a $75 annual fee to apply and get a card. And of course, we'll be doing background checks on the individuals and making sure that everyone is working in the industry that should be. So I wanted to mention that because that would be in addition to what the city of St. Louis would do in their businesses.
Good morning.
Hi, good morning.
I am curious to know how you will ensure that there is equity as you approve these various licenses, specifically with people of color.
The scoring system is fairly sophisticated. We've had a team of attorneys working on this in order to make sure that the license approval process is very fair and equitable. The system will be a blinded system, so names will be redacted. It will be done by a third party vendor will be actually the ones doing the scoring. There are some specific questions in the scoring that deal with diversity, and those are weighted questions that will get bonus points. I think there's a question, the economic impact of the site. There's also one in the business plan, and so there is some weight given to diversity and based on the location of the facilities.
With the use of marijuana going into effect, how does that affect those that use medical marijuana by jobs and corporations when they're doing drug testing? And the other question is, for those who have been incarcerated for the use of drugs or having drugs, how will they be dealing with those who have had charges? Have they addressed any of those issues?
I'll address the second question first. So we as the Department of Health, we can't address anything as far as the incarcerated folks, but I know the legislature is. And we even had, they had some bills this year that I think maybe they made some progress, and there may be someone here that would know more about that than I, but about looking at trying to deal with those that have been incarcerated and, you know, getting them released based on, you know, marijuana charges from the past and that type of thing. As far as the first question, I'm sorry, Rip, what was the first question again? I was thinking about the second one.
How does it affect people that are employed because they do like drug testings and things of that nature?
Sure. That is going to be up to the employers. And actually, we've had a lot of discussions, even with law enforcement and with employers and manufacturing associations and what have you. Let me describe it like this: marijuana is still illegal federally, and so what we're doing, marijuana is still illegal. Okay, we're just taking the industry, the illegal industry, and we're taking a portion of that, just carving out a portion of that and making it legal for medical purposes. Now, everything we're doing has to fit in that box, in that window for medical purposes. So anything outside of that is still in place. Number one, if you've got to have a medical card. If you don't have a medical patient card, then everything you do is still illegal with marijuana. That's the first qualifier. And then you could go from there on the other rules that we have in place. But specifically to answer your question, it is going to be up to the employer, and anything that's still even from an industry standpoint, as far as OSHA or anything like that, you can't be under the influence of anything, operating equipment and what have you. So there's not going to be any protection for that. The other thing about medical marijuana, it's real clear in the amendment, it has to be used in private. So even if you took a dose before work, even though it's in private, if it's influencing your work, you could get in trouble, and that's going to be up to your employers to answer that question specifically. Yeah.
And we also have an attorney coming to talk about policies, employee and employer policies and procedures, and so that's in one of the later panels. I want to jump back, and then I'm going to bring Lindo back to kind of go over the statute a little bit more for this section. But I think that there was a question from you, Steve, regarding full-time equivalents. And the definition that my office uses for full-time equivalent, it means each group of 2 or more full-time or part-time employees who in the aggregate are employed by the same employer for 1,920 hours in a calendar year. So that definition is very specific regarding moving from a part-time employee to a full-time employee. And so that's the definition that we look at to go about determining how many employees that you have. Did that fully answer your question?
Would have to employ probably a large security force to secure the premises. And it seems like they would take up most of the licensing as far as employees. You would have the owner, several workers that grow or cultivate, and 25 security personnel. So that's why I was asking if they would be part of that.
Well, that's part of your business model.
Right.
Yes. And especially, like you said, in this particular industry. Yes, they could be subcontracted out, but then that subcontractor would also have to have a license to do security.
Okay, so I have a question. Why is experience required when this is something new to Missouri?
That's a good question, and that was put in by the drafters, not by us. So I think the thought was that that's why the 51% rule is in there on residency. In order to do this program and do it right, you need people that know what they're doing, and people that have been in the industry. Now, this could also be someone that's worked in the hemp CBD industry, because that's a legal cannabis market. So it would not necessarily have to be someone that's worked out of state. It could be someone that's worked in that part of our industry. Although that's a small industry and still fairly new, that would qualify in that category. So again, put in by the drafters as part of the amendment, and we're going to do our best. I will say this, that even though you may have an ownership in Missouri, they may bring a manager or bring some employees that have worked out of state that have experience. And there's certainly nothing wrong with that as long as the management stays or the ownership stays 51%.
Good morning. Picking up off of her question, will it be then fair to imply that or to infer that if you have more team members who have experience in the health field, whether they be pharmacologists, pharmacists, and even doctor, that it will be more prone to have a more solid chance of getting a license?
I think that would be possible, sure. The way that category is specified, experience in the legal cannabis market is one, but then also, depending on the facility, having healthcare experience is included in cultivation, manufacturing, and dispensary categories. So the more of that you would show in your application, certainly the better score you could get.
And on the other flip side of that is, you don't necessarily need to have those type of background on your team as long as there's validation that it will be able to be properly ranked, correct?
The first part of that I didn't quite
I mean,
catch.
the flip coin of that is it's not necessarily a must that because it's a natural herb, you don't need to have people with that type of experience to be part of the team, as long as the business plan shows that there will be validity in the proper run of the business.
Yes, it would not be 100. It would not be mandatory that you have anyone like that.
Thank you.
But certainly, experience might help. Mm-hmm. Yeah.
As I understand it, there's no special licensure requirements for doctors that are writing what are we going to call them, prescriptions?
Certifications.
Certifications.
Right. That's correct. And that was by design by the drafters, and we honor that. We think the doctors know much more about their patients than we do. And so all we require is that they certify that this patient has one of these symptoms and that medical marijuana might help them. And so that's really all we ask of them. The other thing is to make sure that they see the patient or they certify the patient within 30 days of the application for their patient card. And that they also they are required to examine the patient. Now, there is some questions about whether telemedicine works. If it works now and is qualified as an exam now, then yes, it would also qualify as an exam under these rules.
Once you receive a medical marijuana card, is there an expiration?
There is. It's 1 year. And it's a $25 annual application fee for that. Maybe just ask if nurse practitioners could certify. They cannot. It has to be a medical doctor or a doctor of osteopathy.
Good morning. I just had a question. I know a question came up already around social equity and ensuring that people of color have access, but my question is around accountability. So you have these companies who are coming into communities that are under-resourced. What is it going to look like, or what can it look like for community reinvestment to these communities that have been impacted the most by war on drugs? So people are coming to set up shop in these communities. They have these community benefit agreements that say they'll do X, Y, and Z, but who's holding them accountable for that?
Well, again, we have to refer back to the amendment for all of our rules, which is now the Missouri Constitution. So we're trying to draft the rules to fit under the guise of the Constitution now. The business application process is so important that people apply and state have the very best plan on paper. Now, we're going to have a commencement walkthrough. So even though we initially give them their license within 6 months, 150 days actually, not 6 months, 150 days, then we will also have a commencement follow-up with that. So we issue their license, and then they will have to make sure that they do everything they said they were going to do in their license before we come and give them their final commencement walkthrough and follow-up to assure that they're doing what their license, what they said they would do. As far as accountability, I mean, I think it's going to be up to them following through with the criteria that's in the rules and in the Constitution, Certainly the customers that they have are going to expect things from them. It's still a private business. It's not, these aren't government controlled, government ran businesses. We're not controlling the market. We're not controlling the price. That's all done. It's all private business. So we're just regulating the rules to make sure that they're putting product out there that's safe for the patients of Missouri under the guise of the Constitution.
And I think to follow up with your question is that there is a board bill that has been introduced at the Board of Aldermen level. And so, with any board bills, you also have to have hearings, public hearings. And what this bill does is it regulates the location, the establishment, and the operation of the medical marijuana facility. And so those questions that you have regarding accountability to the community and where they should be located, etc., you need to be present at those hearings so that you can make your voice heard, because this board bill will regulate where they can be located and established in the city of St. Louis. Answer your question? All right. Okay, and so now we're going to go down the statute if we don't have any other specific questions, but we'll go through the statute and pick out other important topics that need to be addressed.
Okay, so this is really not a statute, it's the amendment, which is our Constitution. So just to clarify, because statutes are done by the legislature, but yeah, so this has now become part of Article 14 of our Missouri Constitution. And of course, our purpose is to permit state licensed physicians to recommend marijuana for medical purposes to patients with serious illnesses and medical conditions. This section allows patients with qualifying medical conditions the right to discuss freely with their physicians the possible benefits of medical marijuana use, the right of their physicians to provide professional advice concerning the same, and the right to use medical marijuana for treatment under the supervision of a physician. This section is intended to make only those changes to Missouri laws that are necessary to protect patients, their primary caregivers, and their physicians from civil and criminal penalties, and to allow for the limited legal production, distribution, sale, and purchase of marijuana for medical use. And this section is not intended to change the current civil and criminal laws governing the use of marijuana for non-medical purposes. This section does not allow for the public use of marijuana and driving under the influence of marijuana. So that's the purpose. And that's the first section of the Constitution in this Article 14. I'm obviously not going to read the whole amendment because it's 13 pages long, but I wanted to make sure that everybody understood what our purview is here and what we're trying to do. The next section is the definitions, and there's several definitions listed here, and anyone can pull this up and read these off of our website. And then the next section is creating patient access. And this talks about where we grant licenses, and a lot of the things we've talked about today. We've tried to cover a lot of the important things. There's another piece in this category that's called the seed to sale tracking system. So anytime a plant is grown and started in a cultivation facility, then there will be a batch number assigned to that, and that batch number will follow that plant all the way through the process, through the cultivation facility, the manufacturing facility, the dispensary, all the way to the patient's home. And that's very important, and that way we can keep track of the industry. We can keep track of what's being grown and where it ends up, and make sure it ends up in the patient's hands and not someone else's. We talk about standards for transportation, which we will be issuing licenses for. There's a section in here. Let's see here. We talked about the scoring for the licensed facilities. That's all in this section. We have to issue all the rules, emergency rules, and then let's see, the next section. Again, it did take a long time to just read all these, but I want to make sure we touch on anything that's really important today. There's things like we get into a denial of license renewal. There's a procedure for that, an administrative hearing with the legislature that you can go to or take it to, and that's touched upon. No elected official shall interfere directly or indirectly with the department's obligations and activities under this section. That's in the Constitution. The department shall not have the authority to apply or enforce any rule or regulation that would impose an undue burden on any one or more licenses or certificate holders, any qualifying patients, or act to undermine the purpose of this section. So what that's saying is people have to have access to medical marijuana, and we can't, the local governments can't, the state legislature can't do things to make it burdensome on those patients to be able to get access. We certainly can regulate to keep everybody safe and legal, but not deny. Talk a little bit about taxation and reporting. That's the next section in here. We haven't touched upon this, but in the amendment, the drafters put a 4% tax in addition to your normal sales tax. Like in my hometown, it's 8.125. Part of that's city, part of that's county, part of that's state. But in addition to that, you would also pay a 4% tax that go to the veterans, the Missouri veterans, into a special fund that will be set up and administered through the Missouri Treasurer's Office. And that's to be used by veterans in Missouri. So that's something we hadn't talked about. We fund the program, as I said earlier, through these application fees the first year, but then every year after that will be through renewal fees of all the licensed facilities and the patient cards and what have you. And then any leftover money from the license fees and what have you will go to the veterans along with the 4% tax. So no revenue from this program goes to general revenue except for the normal 8% in my town, or whatever it is in your town. The normal tax would go to the local entities, as we said, but anything above and beyond go to veterans. We talked about physician certifications and us kind of staying out of their way. And again, they're not going to prescribe. This isn't like a prescription drug. They're not going to say that this patient shall have this amount of THC for this ailment. They're just going to certify that the patient qualifies under the category of the ailment. And the patient will be able to receive a certification for up to 4 ounces of flowering plant a month, every 30 days, or the equivalent of. And there's an equivalence chart in our rules that tells what that would be in other types of edible products or tinction products and things like that. If a doctor certifies that this patient really needs more than 4 ounces, that can be done by getting another doctor involved and the two of them together collaborating and say, yes, he could be authorized or she could be authorized to have another 4 ounces in that 30-day period. Mentioned legislation a minute ago. Nothing in this section shall limit the General Assembly from enacting laws consistent with this section or otherwise effectuating the patient rights of this section. But the legislature shall not enact laws that hinder the right of qualifying patients to access marijuana for medical use as granted by this section. So the legislature can do some things, but they can't keep it from happening. That's the bottom line. Marijuana can't be consumed for medical use even in a jail or correctional facility. This is all in the Constitution. Undertake any task under the influence while doing so would constitute negligence or professional malpractice. So that goes back to the employer piece. You can't operate, navigate, or be in actual physical control of any dangerous device or motor vehicle, aircraft, or motorboat while under the influence of marijuana. You won't be able to bring a claim against an employer, a former employer, or a prospective employer for wrongful discharge, discrimination, or any similar cause of action or remedy based on the employer, former employer, or the prospective employer prohibiting the employee, the former employee, or the prospective employee from being under the influence of marijuana while at work, or disciplining the employee or former employee up to and including termination from employment for working or attempting to work while under the influence of marijuana. There is a piece in here about people that have had prior convictions. Let's see. No medical marijuana cultivation facility testing facility, dispensary facility, or manufacturing facility, or entity with a transportation certification, that should cover everybody, all of them, shall be owned in whole or in part, or have as an officer, director, board member, manager, or employee any individual with a disqualifying felony offense. A disqualifying felony offense is a violation of and conviction or guilty plea to state or federal law that is or would have been a felony under Missouri law, regardless of the sentence imposed, unless the department determines that the person's conviction was for the medical use of marijuana or assisting in the medical use of marijuana, or that the person's conviction was for a non-violent crime for which he or she was not incarcerated and that is more than 5 years old, or more than 5 years have passed since the person was released from parole or probation and he or she has not been convicted of any subsequent criminal offenses. The department, that's us, may consult with and rely on the records, advice, and recommendations of the Attorney General and the Department of Public Safety or their successors in applying this subdivision. All edible infused products have to be in a child-proof container, a package that's sealed, and it has to stay in that package until it gets to the home. That's an important one. And most of these we've touched upon already. I think that's pretty much, we've covered most of the other questions, issues. No health insurance no medical marijuana will qualify for health insurance. People should understand that. And if you're a veteran, your VA doctors will not be able to certify. However, you could take your patient file and you could go to a new doctor, a certifying doctor, and by having your existing file, that would help them to determine, because that obviously that prior doctor has diagnosed you with whatever ailment, and that could help your certifying doctor in certifying you. That's it.
Thank you so much, Mr. Fracker. Thank you so much, Ms. Thompson. Ladies and gentlemen, we'll take a few minutes for another break, and then we'll be starting at 10:10 with our next panel. Once again, let's give our panelists a round of applause. Mr. Fracker drove all the way from Jefferson City. Thank you so much, sir. All right, if everyone can be seated, we're about to begin the third panel here in a few moments. I hope you guys have been enjoying the information that's been provided here today. Certainly, I know I've learned a lot. I hope you all have been learning a lot too. I want to introduce our third panel. We're going to be talking about banking, taxation, commerce, a few other items. First, I want to introduce the panel in total. We have Mitch Myers, who is the CEO and patient advocate of the B-Leaf company here in the St. Louis region. We also have Sinette Magnus, who is an attorney at Lewis Rice, our co-sponsor, and we very much appreciate them coming here today and being able to provide some legalese and some expertise to this important topic and this important forum. And last minute, Jim Regner was able to come through and talk about Triad Bank's efforts to do what many other banks have not done, and that is actually open up deposits for individuals who want to be able to use banks like every other commercial business here in the United States of America, as opposed to it just being a cash business. So I want to go ahead and introduce Mitch Myers to the stage. Give her a warm welcome.
Thank you. Like most people in this room, I didn't grow up in the cannabis industry. My background was in sales and marketing, working for some major companies in the St. Louis area. But I ended up spending time in Colorado in early 2000s when their medical program was just getting off the ground. And I ended up having friends that were involved in the business that were treating people as caregivers and other people that were cultivators, and actually just observing what was going on, and realized the help that people were actually getting from this plant. I really didn't have a knowledge of cannabis prior to that for medical reasons, and have since, in the last 5 years of being involved, just witnessed some pretty miraculous results. So I live in Illinois, and at the time we had a bill going through the legislature for a very strict medical cannabis law. And I applied with some other individuals for licenses, and I was very fortunate to receive a dispensary license up in the Chicago area. So once we received the license, I will tell you that, Director Fraker mentioned all the rules and regulations that you have to abide by in making these applications. You also have to deliver on that. So make sure that what you put in those applications that you are capable of delivering, because they have done a fabulous job of responding to the amendment and getting all the rules and regs out. But I also suspect that they're also going to be monitoring us to make sure that we deliver on what we say we're going to do. That training happened in Illinois, and I'm very fortunate for that, because as we've witnessed around the rest of the country, it can be a little bit more lackadaisical, and that's where things start to go off the rails, and you have struggles either getting a bank or keeping a bank. And being a good business person and running your operation correctly and having lawyers and accountants that are overseeing are really a critical part of this program. I also, at the time in 2015, there was a very narrow law passed in the state of Missouri for 2 licenses to be able to grow high CBD plants, hemp basically, and treat individuals with intractable epilepsy. So I applied for one of those licenses, and again was fortunate enough to receive that. We opened up our operation in Earth City in 2015 and began working with neurologists that were allowing access to their patients. Again, I have learned an incredible amount about what this plant is capable of. We've also learned how to grow it correctly and keep those THC levels down. But my biggest learning is in working with the patients and the families of the patients. If you're going to apply for a dispensary license, you need to understand you are almost in the healthcare business, and how you treat the information within your dispensary in terms of HIPAA compliance is very important. How you work with your patients is important. And someone asked the question earlier about should we have medical or pharmaceutical people associated with it. And if you're able to do that, I would encourage it. There are drug interactions. We have learned that. We continue to work through it. I have a chemist with a PhD that knows if someone comes to us, if they're taking certain medications, we need to help either steer them away from the CBD or talk to them about how and when they dose with their others. So, it's not as simple as a retail operation that you're opening up and just buying and selling stuff. You have very seriously ill patients that are going to be coming through your doors. If you do it correctly, you end up with an absolutely amazing relationship with these people. If you can help them and help them through some of their issues, it is the most rewarding thing you'll ever do. So I never thought I would be here. I really should be retired. But when I started doing research several years ago, I went down this rabbit hole, and I can't get out of it. It is the most fascinating thing, and it's the beginning of a new industry. We have the opportunity in Missouri. I always say we're late to the game. We're the 33rd state, but thank you, John Payne, and everyone that worked on Amendment 2. It's one of the better bills in the country for patient access, to help our veterans, to help people that have serious issues, and I'm really proud to be hopefully leading a team to get some licenses and execute here.